affiliated with tactical security services. On this aspect, and on certain aspects raised by counsel yesterday, it's clear this aspect was dealt with in judgment. It refers to the merits, and when we deal with leave to appeal application, it is when the court will hear the merits. The court's finding in judgment is clearly stipulated regarding how possession, there was no finding as to how possession was gained. That is as far as I'm going to say. The rest we'll do during leave to appeal. And some of the controversial statements during, how will I say, reply by replying counsel. That in essence were the points raised by the defense and the social worker, Mdantsane. And as I've stated yesterday, reading the paper gives new meaning when one hears the oral arguments in court. It gives more perspective, insight, to see and hear the tone of how a statement is made as a different impact on a court as a piece of paper which is words. So therefore it was important for the court yesterday to pause when it did and then retire to indeed consider sentence. Those were the aspects as stated, dealt with by the defense, and I will now deal with the aggravating circumstances as indicated or raised by Advocate Caesar on behalf of the state. The state submitted that they request that the court should consider a custodial sentence in this matter for the following reasons: that the incident was planned and it was deliberate and executed with precision, and that the submission is made based on the accused's own evidence. Also on this aspect, I would say we will deal with the merits once we reach that point. Further, that it was a collective decision made by the EFF's leadership, and that it was planned to entertain the crowd to ensure that the crowd is not bored during the event. In this regard, the state relies on the submissions based on the evidence of the accused that, I quote, everything was perfect and calculated and designed to be the way it was done, unquote. Therefore, it was not an act based on a lapse of judgment. It was established that to discharge a semi-automatic rifle in a built-up area densely populated using a .223 Remington round was fired, and that retains lethal kinetic energy on descent. The potential for mass injury or harm was real, it was foreseeable, and scientifically established. Mdantsane is a residential area. The state alluded to the fact that the accused's position as a public leader and role model is, I would say, a fact. Submissions made thereafter by the state requested the court to consider that the accused is a member of parliament and also the president of a political party, admired and followed by millions of South African citizens, and arguing that it is aggravating and not mitigating as per the defense submissions in this regard. The state referred to the video footage which was accepted by court. That again, I will say, deals with the merits. It was clear what footage was admitted by court and what was not admitted. The state alleged that the accused clearly lacked insight and accountability and sought political justification as an excuse, thereby undermining the public confidence in the administration of justice. These submissions was followed by the concerns the state raised regarding the evidence and pre-sentence report drafted by Ms. Thompson and the findings by the witness and the submissions by the defense regarding the brevity of the possession and that it was not accidental, and that the discharge of a semi-automatic rifle cannot be described as benign, and since the risk of injury or harm is extreme. Celebratory purposes in this regard, the state submitted that this type may not be condoned, this type of discharge may not be condoned, and that the law makes no provision for such actions. The state then embarked on the discussion and submissions regarding the case law, which was placed on record. I am not going to repeat, it has been noted. The only difference I may add by the side is that although the state and the defense relied on the same case law, it is clear that the state will use the portions which is beneficial to them, and the defense would obviously use the portions which is beneficial to the defense. And ultimately, at the end, the court is required to bring them together. The fact that the state further continued that the fact that there appears to be no harm or injury caused as a result of the commission of the offense is conceded by the state, however disagrees with the defense regarding the weight that it should be attached by court. The Parliament criminalized the creation of risk, not that there is a requirement of an actual harm or injury, but the actual act itself. The state continued to highlight three, which they termed, I'll say, pointers, that being the imperative of equality before the law. I'm not going to elaborate on that point at this stage. The imperative of proportionality and the imperative of deterrence. Those were the three highlighted by the state. And concluded its submissions by referring to State v. Zinn and pressing trying to also expedite the sentence. Just a minute. The state then submitted that the proposed sentence effect to all the principles and objectives set out in State v. Zinn with safety, and it will satisfy the constitutional mandate of equal treatment before the law, and it will serve the legitimate and pressing interests of a society that has the right to expect its leaders to obey the same laws they are elected to uphold. Now, the court will proceed with the principles traditionally taken into account by sentencing court. It is a well-known fact that sentence proceedings are the most difficult part of any court proceedings. It does not only affect the accused person, but also the family of the offender, including the society, that being the public welfare, safety concern, and the interest of society. It is also known that a court is obliged to consider the normal aspects of sentence traditionally taken into account before imposing sentence. These aspects being the accused is indeed a first offender before court and has no outstanding or pending criminal matters. It also includes the possibility of reoffending. I'm not going to elaborate on that aspect. It was done by the defense. It is noted as one of the principles to be taken into account. It also includes loss of employment. In this instance, the case law is clear that should sentence result in the loss of employment, it should be noted that crime is an inevitable consequence of crime, or loss of employment is an inevitable consequence of crime. The court is also obliged to consider the family of the offender. This fact was fully discussed in the pre-sentence report submitted by Ms. Thompson, who testified in mitigation of sentence. On this score, I also think it is appropriate to highlight, I do not intend to discuss the depth of the pre-sentence report, as was submitted by the defense in the heads yesterday, orally, that I accept it was an invasion of the accused's personal space. It could never be seen as an easy exercise. And we heard that evidence of Ms. Thompson, I think, in excess of 5 hours on the 23rd of January. And I think that in itself was surely not a pleasant experience. So I'm merely going to highlight how I have highlighted the content and then the family, etc. I do not intend to rehash personal circumstances which has been dealt with or heard. The other aspect that the court needs to consider is the state of health of the offender, and the court was informed that the accused does not suffer of any medical or physical ailments as per the report. Youthfulness, it is so that the accused is still relatively young. And most importantly, the position of trust. This is one pointer that the court will return to. It requires full reasoning by court, and I will do so during the process of sentencing. The further aspect is that the prevalence and seriousness of the offense. This is an aspect the court cannot shy away from today, but also requires full reasoning, and the court will do so during the proceeding of the sentence. Those two aspects. The above are but a few pointers traditionally taken into account by courts before sentence, and some require a detailed explanation by courts. It is well known that the ends of justice are four in number, being deterring, preventative, reformative, and retributive in its nature. It, however, consists of 5 important functions. It should act as a general deterrent. It should also act as a specific deterrent. It should also, or it must enable the possibility of correction. And it must be protective of society. And it must further also serve society's desire that crime be adequately addressed by courts. It is in the public interest that punishment be meted out fairly and without the measure of excessiveness that would mark it as being merciless and unacceptably unfair. The court is mindful that neither the call for true punishment and revenge, neither the cry for understanding must be given undue weight. The ends of justice, as mentioned already, must be given due regard when determining sentence. And it is required that a court should strive to accomplish and arrive at a judicious counterbalance between the elements mentioned and ensure that one element is not unduly accentuated at the expense or exclusion of any other element. It has been often stated in various case law that the sentence imposed should fit the offender as well as the crime. It must be fair to society and blended with a measure of mercy according to the circumstances of each matter. True mercy, therefore, has nothing in common with soft weakness or maudlin sympathy with the offender, since it is a crucial element of our justice system in its own right. It is also not an element that mere lip service is paid to, but indeed a sound factor that each court must consider and which must clearly reflect in the sentence imposed. However, courts are required not to strive, as stated, for severity, but neither, on the other hand, surrender to misplaced pity, and should not flinch from firmness where it is called for, and that a court should be strict enough to ensure that the objects of punishment are adequately furthered, and indicating thereby that crime will be effectively punished. Having said that, this court is well aware that a court should approach its task with a humane understanding of human behavior and frailties. Just a minute. I've been talking a lot, just a minute. I think at this stage, while we are still proceeding calmly, I'm going to deal with general concerns when reaching sentence regarding matters of this nature. Thereafter, the court will deal with the or reply to the offense before court or the matter before court. It should be noted that crime is inconsistent with the rule of law and the fundamental value of our Constitution. It undermines the constitutional commitment to human dignity and further the achievement of equality, including the advancement of human rights and freedom. Crime is therefore the antithesis of an open, accountable, democratic government as required by our Constitution. Chaskelson P. in South African Association of Personal Injury Lawyers versus Heath and others, 2001, SA 1883, Constitutional Court, 2001, in brackets 1, states that, I quote, elected office bearers and officials in the public service have become one of the most serious threats to our country's well-being, and that is to state the obvious. Although the mentioned case deals with corruption and crimes of dishonesty, it is still relevant to crime in general, and as far as it relates to public office bearers, as the impact and consequence pertaining to the matter before court today remains the same, if not worse. It is clear that if crimes are allowed to go unchecked and unpunished, it poses a serious threat to our democratic state. Crime in South Africa is ever escalating, and it appears to be an acceptable way of life in our country, this being a situation the courts cannot allow or tolerate. The incidents may well be characterized as a pandemic that needs to be recognized as such and requires concerted and drastic efforts to combat it. It is regrettable that too often in South African courts, the so-called, and I quote, non-violent crimes have been visited with lenient sentences due to the classification of no violence, and that perpetrators of these offences are seen as not to be truly criminals or even prison material due to their ostensibly respectable careers and lifestyles. The above-mentioned case stated on record speaks about dishonesty. However, this court will dare to say that it does not merely refer to related offences such as fraud, etc., but it includes the dishonest character of an individual, indicating that such conduct entails gross breaches of trust. At the beginning of the sentence, the court mentioned the element of trust and that a court should consider before imposing a sentence, and based on the facts of the matter before court, including the circumstances in which the offences were committed, it shouts of the breach of trust and is of great concern to this court today. The accused is in a position of trust and elected as such by the members of society. The conduct of the accused and the effect of his actions and the impact of the conviction on the accused combined all reflects, contrary to what is expected from our Constitution, the complete absence of accountability and breach of trust by the accused person before court. Going to try and summarize the response to the defense submissions as follows. It must be noted, and the accused confirmed, that the event was planned. Emphasis on the word event was planned, and that it was a unique established tradition planning an event. Firstly, I stand corrected on this aspect, but what I should have clarified is the following, that this was, according to the knowledge of this court, the fifth birthday celebration was the first of its kind. I do not understand the wording of it was a well-established tradition. We heard that the 10th birthday celebration, what the main feature was, but whether it was an established tradition at the 5th birthday celebration, I'm not aware. As a result, it is a great concern to this court that an event was planned and that what appears to be the unique feature of the event ended up in the commission of an offense or offenses. Surely this can never ring true. As per the submissions, the court is asked to consider that the accused had planned the event, and then it goes a step further, because contrary to the view of the defense and the view of the state, today it is clear that the planning included that the accused will possess or take possession of a semi-automatic rifle, fire a .223 Remington bullet into the air, thereby causing possible harm to person or property in a built-up area. That it is now called a celebratory shots, that is sugarcoating. Nothing more, nothing less. the facts found by court during its judgment, and this is not merits, these are facts. I'm going from memory. It was the evidence considered was that the accused had decided that the event was planned by the leadership. All decisions were made by the leadership. So there can be no doubt that you are saying the unique feature of the event was committing 5 offenses. That is the bottom line. Clearly, planning of this nature is in contrast with the law. How can a court of law consider that the actions of the accused did not intend or did not entail the intention to commit an offense? It is not it is not the thinking of the court, it is the facts before court, because that is what happened. It wasn't, as the state correctly stated, an act of an impulsive act. It wasn't, as a result of the case law we heard, an act of passion. It wasn't anger. It was the event of the evening. And therein lies the difference. It should take considerable planning for an event of that magnitude, and I'm deviating from my written judgment, of that magnitude, that as to how, when, and exactly at what time you will take possession of the firearm, where you will fire it from, at which point we all know then, Mr. Snyman, you returned the firearm to Mr. Snyman. That finding was made by court. The court did not find it was handed to you by Mr. Snyman. That is what I'll say in that regard. So that, to reason any otherwise is nonsensical. This is a decision that a person made to possess a semi-automatic rifle unlawfully, and including the decision then to proceed and fire the said rifle in a built-up area in a crowded stadium. The decision to break the law has been made, and it was made with the approval of the accused person and the leadership. Since it's confirmed that this was the future planned for the event, it clearly indicates that the accused had known it was unlawful. He knew that it may cause harm to persons or property. He knew all the above, and it yet proceeded to possess the rifle and to fire the shot in celebration of the 5th birthday celebrations of the economic freedom fighters. Always knowing when this was being planned, arranging this special feature that it is in contravention of the law. And that this decision was made long before the actual event. Such acts can never be condoned by this court in any instance. The court cannot dismiss these actions planned by the accused as mere celebratory shots, and further justify the commission of crime under the pretense that it was celebratory shots. Much has been said yesterday regarding other offenders who've committed acts of this nature, worse, who have not been brought before a court of law. This court is not in a position to answer for those matters. Safe to say, I trust that surely the long arm of the law would reach and bring those offenders or suspected offenders before court. This court can only reply and answer for the matter before it, not for what has been said was done by Mr. A to Z or Miss A to Z. I'm unable to do so. My focus is on this matter solely. With regards to, yes, as I say, as far as it pertains to individuals who had committed the same offences and had not yet been brought before a court of law, should this type of reasoning be condoned, it is clearly not conducive to the interest of society, and the courts are required to act accordingly. And that is as much as I can say regarding the offenders who are still to be brought before courts. The other aspect that is aggravating in this matter and which needs to be mentioned is the astronomical financial impact this matter has had on the taxpayers' pockets or at the taxpayers' expenses. By saying that, please, that is not laid at the foot of the accused person solely, not at all. It was your right to take this matter on trial. I'm saying merely that a trial of this magnitude involved tremendous human or manpower. If we look at the ballistic side of this matter alone, the transport of firearms from KZN to Quebeca and back, the ballistic unit's resources and equipment, preparation, SAPs. The tragedy is that this matter has also led to so many people that did not have access to this court on several days where this matter proceeded. Mothers could not approach the court for maintenance. They could not reach inside. Grandmothers could not come to the offices to apply for foster care or guardians, appointment, adoptions, domestic violence. Those people did not have access. And that is tragic. These are members of the community this court services on a daily basis. They wake up, as you very well know, all of us very well know, by 3 a.m., by 4 p.m., those little kids are dressed, washed, and they walk to court. And yet they cannot reach the entrance of this court for the help that they need. What has transpired is indeed sad. It's a sad day for justice if this is what bringing a matter of this nature to court results in the impact on the interest of society. And as I've stated, the courts must protect the interest of society. Not only did it affect those people I've mentioned, courts adjourned early. Our court rolls are overcrowded beyond comprehension. Inmates had to be returned to correctional services, leading to the extension of the overcrowding of prisons or correctional facilities. Witnesses who traveled from far, who lost a family member, let us say in a murder incident, they did not get closure on a specific day which was allocated to them for their matter to be heard. They have to come back. So yes, this matter indeed is sad because it has an immense tragic effect on the administration of justice and the very interest of society that is to be served by justice and its staff and courts. And that is not overemphasizing, that is a fact and a reality. The only aspect I'll mention with regards to the time frame of the actual possession of the rifle, yes, indeed, I agree it was very short. I agree with the submissions of the defense that, yes, the charge sheet mentions 1.223 Remington cartridge, correct. I agree that the charge sheet mentions 1 SPA 249. Therefore, the court is limited to what you have been charged for, and that is what I'm dealing with. Nothing more. Safe to say then, on what the court has already alluded to, the commission of these offences are not insignificant, and the impact thereof remains the same. Whether it was done in less than a minute, the impact remains the same. Now, this is a difficult matter to raise because it was alluded by the defense that should a custodial sentence be imposed by court, it will show that the accused is singled out to endure a harsh sentence. To this, the only reply from court is, it is not the court who has singled out the accused person. He had done so all by himself, not the court. In the light of the position that he holds as the CIC of a political party with massive support, it's not the court who had singled out the accused person. The fact remains there is a significant amount of accountability on the accused, and on this regard I'll add the following, that please remember, it is not a political party who has been convicted here. It is not the economic freedom fighters that have been convicted. It is a person, an individual, who so happens to be the CIC of a political party. Nothing more, nothing less. It's not the party. It's an individual, and that is how it is perceived. And while I'm on the topic which is uncomfortable for everyone, let us continue with this political trend that has followed. This court heard, as I've stated, plus minus 19 witnesses. Not a single witness testified before this court testified regarding any political facts, or that is not facts before court. The evidence or political agenda was raised by the accused, which is your right. But those are not facts as part of the state's case. And that's where it ends. A court of law and politics do not blend. The two do not collide. Judiciary stays in its lane. Politician stays in their lane. The easiest way to explain this is, I think the minds of a jurist and the minds of a politician do not function on the same frequency at all. Hence, a court is expected to remain independent, dispense with justice without fear, favor, or prejudice, and that is the duty of this court. The rest is of no interest, only the law. Just a minute. On this topic, I'll end off by saying, at all times, the judiciary, including the justice system, will never be intimidated by any politically charged utterances or parties. There is no room in a court of law dealing with a criminal offense for the court to enter into politics at all. And the courts are required to do all in its power to combat the situation and to ensure that all would-be offenders or offenders who are still to be brought before justice faces the full arm of justice. And surely if this is not done or goes unchecked, as I've stated, it will result in the perception that crime is an inevitable consequence of life in South Africa. It must further be noted, as much as the rights of the accused has been emphasized, and correctly so, as it is enshrined in our Constitution, members of society too enjoy rights, the same rights as enshrined in our Constitution. These rights are not one-sided and enjoyed by all. I'm about to end off. I just want to briefly refer to our engagement yesterday in the oral submissions by the state and the defense regarding the two case laws submitted, one by the defense and the other by Advocate Caesar. Just want to get to the relevant part. Yes. The matter submitted by the state being Romeo Jansen and the state, case number CANR 220/18, delivered by D. Van Sale, then DJP, and by the defense, that of the Malundana case, case number CC20/2024, delivered by Brooks J. Now, in this instance, it was interesting to read both. And what is abundantly clear is that in the matter presented, the Malundana case, the facts are completely opposite as the ones we are dealing with today. In the matter submitted, the Malundana matter, was a gentleman of 62 years old who had, after a very long period of time, secured employment as a security officer protecting a school, which led to him firing a handmade firearm. The difference in that matter, which the judges considered as sentence and mitigation of sentence, is the accused there had pleaded guilty he had also spent a period of time incarcerated, 4 months in custody before. Further, he was also a first offender. He had assisted the victims at the scene, and he himself had called the police to come and assist. He had also contributed to the costs of the family who suffered in the incident. That is the set of facts unique to that matter. Now, what is interesting in the Mdantsane matter, counsel argued yesterday that the matter cannot be of assistance to the court. I disagree on that aspect. Indeed it was. Because I think it was said that he had previous convictions, Mdantsane. But when you read the actual judgment, the judge states clearly that the accused was treated as a first offender despite having previous convictions. So that is not relevant. That was he said, and he was found to be or having been in possession only. There wasn't a crime that was committed on the day he was arrested with the firearm. And then interestingly, after being asked by the defense that all people be treated equal, it was submitted that Mdantsane is a gangster, therefore a member of Fat Boys, and therefore sentence of custodial sentence is in order. I failed to see the reasoning and the rationale behind that, but what is evident and clear after discussion of all the cases submitted by the state and the defense, in the view of this court, each case is unique. Every person is equal in law. What does equal mean in my view? That the court should ensure that accused rights to a fair trial is protected and that it applies equally to every individual who appears before a court of law. Sentences, we have this contradiction and variety because, as I've stated, each set of circumstances and facts are unique. If we take, without disrespecting a gangster, we cannot say for gangsters, right, there's a sentence of 5 years. For politicians, it should be 6 years. For the homeless person, it's 10 years. No. It's done in its totality. And unfortunately, the accountability on a public office bearer is a lot more. It weighs heavy than that of the regular South African person. So by saying that, that doesn't mean you are not treated equally or the accused is not treated equally. That is not what equality, in my view, entails. I'll end it shortly. There we go. I'm nearly done, just a minute, please.
Worship, if I may, this is, I'm so sorry about this. I need an urgent comfort break, Worship. I've been sitting here since 7:30 this morning. So sorry about that.
I'm going to single you out, Advocate Caesar.
I try
So I was perusing the file to end off, but okay, can we then say, I'm sorry for this then, but instead of 5 minutes, it's a large crowd. Shall we say this is then the tea adjournment? We come back, we continue then thereafter? I'm sorry for this. No, but we couldn't quite official. I cannot. Just now we all drown when that man cannot cope. Okay. Please, I'm going to just a minute. Sorry. Feel free to. I'm going to leave this. To come back and continue. are back on record then for resumption of RC 446 of 2020, and I will proceed where we left off. Just a minute. I will then proceed and in summary just add the following before pronouncing the sentence, is that we should also keep in mind the magnitude of the offense that the accused has been convicted of. We've heard daily or weekly of children playing in their front yards in the street who are caught in crossfire, random shots fired, killing people. It's just the first time that we hear it's being called celebratory shots. And in essence, the accused, all as stated, are equal before law. But in your instance, it cannot be said that you are not accountable due to the position you find yourself in. You are accountable to members or citizens of this country, to your followers, to the youth. And that accountability stems from your position. And that is where I'm going to end this. You may please stand up. Not the court only. I'm sorry. Maybe I should be clear. Okay. Sorry for that. All right. After careful consideration, and I can show you I have done so, free of any interference, this judgment or sentence is the sentence of this court and this court alone. In respect of count 1, you are sentenced to a period of 5 years imprisonment. In respect of count 2, you are sentenced to a period of 2 years imprisonment. In respect of count 3, you are sentenced to 20,000 rand or to undergo 6 months imprisonment. In respect of count 4, you are sentenced to 20,000 rand or to undergo 6 months imprisonment. In respect of count 5, you are sentenced to pay a fine of 20,000 rand or to undergo 6 months imprisonment. In terms of Section 280, subsection 2 of Act 51 of 1977, the court orders that the sentence imposed in respect of counts 2, 3, 4, and 5 run concurrent with the sentence imposed in respect of count 1. You may be seated. Thank you. May we, Advocate Otis, sorry not to interrupt you, may we just deal with the Section 103 inquiry and then we can proceed to that part? I assume you are ready for that part as soon as we've dealt with the 103 inquiry. Certainly. Okay. Let me just find my notes here. Just as a brief explanation to unless it's not clear, the next step after sentence is that the court is obliged to deal with the provisions of Section 103, subsection 1 of Act 60 of 2000, meaning that the determination of unfitness, as I've explained in the beginning of the sentence, should not be made separately before sentencing, as information relevant to such fitness may emerge during the process of mitigation or circumstances, and the inquiry in terms of Section 103(1) Act 60 of 2000, since in terms of Section 1, the accused is deemed unfit to possess a firearm or license in future by virtue of having been convicted of a crime specified in Section 103 subsection 1 of Act 60 of 2000, and reasons may therefore be advanced or evidence presented to enable the court to consider the possibility of determining otherwise. So, Advocate Holders, no submissions. Thank you. Advocate Caesar, on behalf of the state. Due to the reasons provided by court during sentence and that we are dealing with unlawful possession, due to the virtue of the nature of the offences, the court therefore makes no otherwise order, and you remain to be deemed unfit, and it is followed by the following further order by court, that Section 103, subsection 1, read with the provisions of Section 104 of Act 60 of 2000, the accused then remains to be deemed unfit, and the effect of the declaration of unfitness is as follows. All competency certificates, licenses, authorization, and permit issued in terms of this Act to any person who becomes or is declared unfit to possess a firearm in terms of Section 102 and 103 cease to be valid from the date of the conviction or the declaration, as the case may be. B, despite the noting of an appeal against the decision of a court or the registrar, the status of unfitness contemplated in paragraph A remains in effect pending the finalization of the appeal. Further, a person who becomes or is declared unfit to possess a firearm in terms of Section 102 or 102.3 of Act 60 of 2000 must within 24 hours surrender to the nearest police station all competency certificates, licenses, authorizations, and permits issued to him or her in terms of this Act, all firearms in his or her possession, and all ammunition in his or her possession. Therefore, it should be noted that subject to the provisions of subsection 9, subsection 3, subsection B, and after a period of 5 years calculated from the date of the decision leading to the status of unfitness to possess a firearm, the person who became or becomes or deemed and declared unfit to possess a firearm may apply for a new competency certificate, license, authorization, or permit in accordance with the provisions of this Act, being Act 60 of 2000, the Firearms Control Act. Okay. All right. So what we are left with is the application. Are you ready to proceed now? Okay. Let me just get that part of it ready. I'll be with you now. Yes. Just a minute, Advocate Holders. I just want to quickly grab the notepad. I haven't drafted that, so I'll have to listen to you carefully here. Just a minute. Okay. Thank you. Yeah, I'm ready.
application for leave to appeal, the High Court of South Africa, Eastern Cape Division, held at Grahamstown, against the whole of the judgment convicting the accused of firstly, unlawful possession of a firearm in contravention of Section 3 of the Firearms Control Act 60 of 2000, to wit a .223 Narinka rifle and or a firearm the make of which is unknown to the state without holding a license, permit or authorization. The second count, Your Worship, that we seek leave to appeal against is unlawful possession of ammunition in contravention of Section 90 of the Firearms Control Act 60 of 2000, to wit a .223 Remington bullet without holding a license, permit, dealer's license, manufacturer's license, gunsmith's license, import or export or transit license, or other authorization to do so. The third count, Your Worship, is unlawful discharge of a firearm in a built-up area or any other place in contravention of Section 120 sub 7 of the Firearms Control Act 60 of 2000, to wit the CISA Prakashi Stadium in Mdantsane. The fourth count, Your Worship, is unlawful failure to take reasonable precautions to avoid danger to personal property in contravention of Section 120 sub 3 sub C of the Firearms Control Act 60 of 2000, in that the accused of control of a loaded firearm, to wit a .223 Narinka rifle and or a firearm the make of which is unknown to the state, in circumstances where it created a risk to the safety or property of the general public, attending the 5th Economic Freedom Fighters celebration. And finally, the fifth count, Your Worship, is reckless endangerment to a person or property in contravention of Section 120 sub 3 sub B of the Firearms Control Act 60 of 2000, in that the accused unlawfully discharged or otherwise handled the firearm, to wit a .223 Narinka rifle and or a firearm the make of which is unknown to the state, in a manner likely to injure or endanger the safety or property of the general public attending the Economic Freedom Fighters celebration, residents of Mdantsane and the employees of Gear House, with reckless disregard for the safety or property of the general public attending the 5th Economic Freedom Fighters celebration, the residents of Mdantsane and Gear House employees. The Worship, this application for leave to appeal is based upon the following grounds of fact and law. Firstly, this is in relation to the convictions, Your Worship. In assessing the evidence, having acknowledged that the court was obliged to evaluate circumstantial evidence in this matter, the court had regarded to the often quoted dictum in Rex v. Blom and held that there are two cardinal rules of logic which cannot be ignored. And there's a quote from Your Worship. There are firstly that the inferences sought to be drawn must be consistent with all the proved facts, and secondly, the proved facts should be such, and Your Worship said, I quote, that they exclude every reasonable inference from them save the one sought to be drawn. Yet, we say, Your Worship, that Your Worship, the magistrate, committed a material misdirection not having any alternatively sufficient regard to all of the facts that militated against the guilt of the appellant, of the accused at this stage, Your Worship. We say that this occurred despite, Your Worship, the magistrate having held, and there's a quote here, Your Worship, the court must not take each circumstance separately and give the accused the benefit of any reasonable doubt as the inference to be drawn to each one so taken. It must carefully weigh the cumulative effect of all of them together, and it is only after it that it has been done so that the accused is entitled to the benefit of any reasonable doubt which it may have as to whether the inference of guilt is the only inference which can be reasonably drawn. To put this matter in another way, the state must then, as stated, satisfy the court that each separate fact is, let me rephrase as stated, the state must satisfy the court not that each separate fact is inconsistent with the innocence of the accused, but the evidence as a whole is beyond reasonable doubt inconsistent with such evidence. Yet we submit that Your Worship committed a material misdirection not having any alternatively sufficient regard to all of the facts that militated against the guilt of the accused. In this regard, we say further that Your Worship further erred in holding that, and there's a quote, a number of circumstances, each individually very slight, may so tally with and confirm each other as to leave no room for doubt of the fact which they tend to establish, though each taken by itself, but as light as a feather, however, join them together, you'll find them pressing on an individual with the weight of a millstone. And we say that you further erred in this regard, Your Worship, when you held. It is further described that in cases surrounding circumstantial evidence, and circumstantial evidence alone. Evidence varies infinitely in its strength in proportion to the character, to the variety, to the independence one of another, and one might describe it as a network of facts cast around an accused person. That network may be that strong as it is in part, and it may also leave gaps and may then allow the accused person safe passage. It may be so close, so stringent, so coherent in its texture that no efforts on the part of the accused can break through. It may also come to nothing, and or on the other hand, it may be absolutely convincing. The law does not command that you should act upon certainties alone. We often ought to act upon just and reasonable convictions founded upon just and reasonable grounds. The law asks for no more and the law demands no less. I further refer to State v. Kwanda, 2013, 1 SSCR 137, Supreme Court of Appeal, where Maria J. stated that such an inference is only justified where the state has established facts from it can properly be inferred by a court. We say the court mentioned but only paid me a lip service to the issues raised in argument on the merits on behalf of the accused, did not have sufficient or due regard thereto. In this regard, the court mentioned the 23 statements by the investigating officer, Colonel Swartboy, the lack of DNA or fingerprints linking the accused to the firearm, no eyewitness complaint, and various other factors relating to a 9mm Glock firearm and ammunition. However, the court did not take these factors into account in its application of the two cardinal rules relating to the admission of circumstantial evidence. We go further, Your Worship. We say, additionally, the court's assessment of the circumstantial evidence and acceptance thereof did not have regard to the absence of any damage to any structure and the inability to link the suspected firearm and spent cartridge to the accused. Other significant factors in this regard were that no person reacted in fear, and the 5 VIP SAPS members had not witnessed any shooting.
I'm sorry, if you can just mark there where you are busy with. She's informing me that there's a sound coming that she needs to check from our court recording machine, and I just please don't want anything to go wrong with our recording of the stage of the proceeding. So she's asking that we just adjourn for her to check and that all cables, etc., are in place. I'll just leave, please. I'm not going to pack up everything, just leave it here, and then I'll be, when you're ready, they'll indicate to the police and I'll enter. Thank you. Court will adjourn. Wouldn't be nice to move. Have you seen it? Thank you. It's not yet. Please be seated. Abongile. Sorry, Advocate Oda, she says it's not yet. Oh, you must go ahead. Okay, sorry. She said you'll go ahead and she'll indicate if it's now clear. Thank you.
The next point that I wish to make is the court summarized the facts in dispute and held that it all announced whether the firearm that was fired on the night in question was a real gun or a toy gun. This issue is not resolved beyond reasonable doubt by the evidence led in this matter. Consequently, the accused was incorrectly convicted of the charges. Then the court further erred in allowing the viral footage to be viewed without it having been authenticated. In this regard, the court took issue with the defense having relied on the footage during cross-examination of state witnesses and the presentation of the accused's case. The court subsequently held the facts which the court will rely on without giving any real regard to the viral footage and no further findings required regarding the said footage. So what we're saying is, Your Worship said it's real evidence, it was allowed, it was referred to, and eventually Your Worship said it's not inadmissible, it hadn't been proven. Then we say the court further erred in having regard to the state witnesses en masse and holding that they were credible, reliable, and truthful. And the court cannot find any bias, prejudice, or any motive in the evidence of any of the state witnesses to indicate otherwise. This was premised upon the court having been very impressed by Colonel Ngwadleka, who was described as being a brilliant witness and had left no stone unturned. He had dotted every T and dotted every R. He had not made any mistake as far as the custody chain or the handling of the exhibits or serial numbers contained. The court finds him and all the above then as stated credible, reliable, and truthful. The extent to which the court had been impressed by Colonel Ngwadleka was further evident from the finding that he meets the criteria, in fact exceeds the required criteria in his thoroughness, and he can be, or is mentioned by this court to be not only an expert witness but a super qualified expert witness. That is the conclusion regarding Colonel Ngwadleka. This evaluation was in turn projected by the court to the rest of the state witnesses, even though there was no factual basis to do so. This in itself indicates a material misdirection by the court in its approach to the evidence of the state witnesses and the assessment of their credibility. In contradistinction, the court held that the defense witnesses, including Mr. de Klerk, were defensive and at stages argumentative. This is further borne out by the comparative analysis by the court of the evidence of Mr. de Klerk as compared to Colonel Ngwadleka, which was found to fall short and only be noted as mediocre. This biased approach to the testimony of the defense witnesses is further illustrated by the approach adopted towards the accused. The fact that he had stated that Mr. Mavundla should have been charged was utilized to discredit him. Additionally, he was found to have evaded many questions that had warranted a reply. The court held that it became evident that the replies were entertaining, but however the pertinent questions asked remained unanswered. He was further criticized for relying upon the viral footage whereas nobody else was. Having held that the court had to establish whether the version presented by the defense was reasonably possibly true, regard was had to the statement in cross-examination that the firearm had been in Gauteng. In this regard, the court held, and I quote, "Now as to what happened and where it was kept, no explanation was provided. It begs the question, dealing with circumstantial evidence, that what does the firearm being booked out to Mr. Mavundla in effect equate to that specific firearm is booked out to him for whenever it is needed for him or by him. Since clearly it does not mean it needs to be on his body since he left it in Gauteng. In doing so, the court appears to have lost sight of the fact that this statement had been made by the co-accused counsel in cross-examination. There was no basis to attribute it to the accused. These findings by the court indicate the application of a type of reverse onus upon the accused to prove his defense, whereas, as stated by the court, the accused version only had to be reasonably possibly true. Put differently, the application of the two cardinal rules by this honourable court had to exclude the accused version being reasonably possibly true. Then we say this misapplication of the onus is further evident from the court having, in its concluding remarks, confirmed the two cardinal rules that require the inference sought to be drawn to be consistent with all the proved facts and to exclusion of every reasonable inference from them save the one sought to be drawn. This could never be the case in the absence of any objective corroboration that one would have expected to be present at the scene, such as damage to property, injury to people, or at the very least an expression of fear by anybody from the many people that have been in attendance at the celebration. And finally, in relation to the conviction, Your Worship, what we say is at the very least, it cannot be said that now the court might find differently or have a different assessment of all the evidence led in this trial. Consequently, it is respectfully submitted that the accused is not only a reasonable but a good prospect of success on appeal, and this application for leave to appeal against the convictions ought to be granted. In relation to sentence, Your Worship, we submit the following. We say that the sentence imposed by this Honourable Court is startlingly inappropriate to the extent that it induces a sense of shock. We say further, due regard being had to the prevailing circumstance at the time of the commission of the offences, and more specifically that they all relate to the same event in a very limited period of time that did not exceed 1 minute, all of the counts ought to have been taken as one for the purpose of sentence. There is no need or basis to impose separate sentences in respect of each charge, as this court did. We say further, insufficient regard was had to the personal circumstances of the accused. Most significantly, he is a 45-year-old first offender who was 37 years old when these offences were committed. He has not been convicted of any other offences in the interim. Additionally, he is married. He has 3 children and a wife to support. He is in full-time employment. He is also involved in community projects and regarded as an asset to the community. There is no basis to contend that he is a danger to society, thus ought to be removed from society. In this regard, Your Worship, I wish to highlight that no regard is had to the fact that he's led a blameless life during the duration of this trial, and he hasn't committed any other offence, and this was not taken into account in the sentence that was imposed. Furthermore, when it came to his community project, Your Worship questioned the social worker who testified, Ms. Thompson, in relation to the soup kitchen under a question to clarify, and it went as follows, Your Worship, just to indicate the approach of Your Worship. It's at page 163 of the record. Your Worship says at line 16, okay, let me leave that. I have only 2 aspects left, no few in fact, because if I had it before the time, it may have been a different story. The other issue, not an issue, but if you can explain. I think we go in the circle of a radius of 5 kilometers on each side of the court building. We're going to find about 4, 5, 6 soup kitchens. So, and this soup kitchen is specifically to the area of Mr. Malema is coming from. Ms. Thompson says, correct, Your Worship. The court says, so that is, what value must the court attach to that? Because I read it is from donations. Ms. Thompson says, part of, yes. And through the facilitation of the involvement of the accused, Your Worship. So Your Worship says, so it will continue. She says, it will continue most likely, yes. The court says, okay, so there's nothing special about the soup kitchen. Ms. Thompson says, there is. Then Your Worship cuts her, and Your Worship says, except that he may want to be very thankful that people are being served a meal that is outstanding. Ms. Thompson says, yes, Your Worship, and it was mentioned as part of the consideration in terms of the risk of reoffence. So the point we're making, Your Worship, is Your Worship undermined with respect the role that the accused makes to society. Put quite differently, Your Worship, neither, to my knowledge, does Your Worship or anybody else in this court have the right to claim that they started or initiated a soup kitchen, but Your Worship belittled that approach by saying there's so many of them that they don't need him, whereas it was he who initiated it. So I needed to make that point. Turning to a more detailed list of what Your Worship had dealt with today. At the outset, Your Worship foresaw an application for leave to appeal. When Your Worship said, as to the firearm received from TSS, I dealt with this in my judgment, it will be an aspect for leave to appeal in the merits. There's no such finality in my judgment. This will rest until the leave to appeal. So it's quite clear with respect, Your Worship, that you envisaged that there would be an application for leave to appeal, and that, with respect, permeated your judgment on sentence. When it comes to aggravating circumstances, Your Worship, you said that Advocate Caesar had highlighted and submitted that a custodial sentence was a normal, or was the right sentence because this was a deliberate and executed with precision. And once again, Your Worship said these merits will be dealt with when we reach that point. So what we submit, Your Worship, is it was always envisaged by Your Worship that there would be an application for leave to appeal, and that this sentence bears that out. Your Worship also dealt with the accused being in a position of trust. Now, when we refer to a position of trust, Your Worship, is ordinarily a person who's an employee who looks after money or an assets on behalf of somebody else. It doesn't cover the situation dealt with in this matter. And we've never ever argued that there's an absence of accountability and a breach of trust. But all of this, Your Worship, will come to the final quote that I'll address Your Worship on before I make my conclusion. And that's to the effect that Madam Justice is meant to be blind and deaf, Your Worship, and not have regard to the actual specifics of the person when sentencing in the manner that Your Worship did so here. Now, Your Worship also asked the following in your sentence. You said, the event was planned, the accused said so. I stand corrected on this aspect. It was the fifth celebration, first of its kind, and I was told that it was a well-established tradition. She said, Your Worship said, I'm unsure about this. Now, Your Worship could have clarified that. The evidence was there, but you do say in your sentence, you say as a misdirection. Your Worship went further to say it was planned, the whole event was planned and ended up in offences being committed. That can't be true. Now, with respect, we say it's a self-defeating argument, because if one says it was planned, then one must take into account that having been planned, there were no injuries, there was no damages, nothing untoward happened to anybody, and nobody expressed any fear. But that doesn't find any place in Your Worship's judgment on sentence with respect. And Your Worship then referred to the term of celebratory shots as an instance of sugarcoating, nothing more, nothing less. And we say in that regard, Your Worship erred, because it's Your Worship's finding as well, it was part of Your Worship's questioning of Ms. Thompson, that if it's my birthday, can I go down the street and start shooting? And she said no. You said, well, aren't those celebratory shots? So the court knew all along that it was dealing with the celebratory shots, and that was the instance that had been clarified throughout. It wasn't a case of being part of another offence like a murder or anything. And if one draws a distinction here, Your Worship, and this is where we say you erred as well, in relation to the case quoted by my learned friend in this division. Firstly, that predated the one that we referred to. So it was taken into account when the second one was a non-custodial sentence by Brooks. He had already had regard to that full bench decision and didn't feel bound by it. We say those circumstances are clearly distinguishable. The man was a member of a gang. He had been involved in shooting their previous convictions. There cannot, with respect, be any parallel drawn between that. He was in possession of an unlawful, unlicensed firearm, and somebody being handed a firearm and shooting a shot in the air, as is the conviction here. Your Worship also went into the merits of the matter when Your Worship said there should have been planning as to how, where, and what time you would take possession of the firearm, whereas there was no evidence to this effect with respect to Your Worship. Your Worship also said that such actions cannot be condoned by the court and used to justify shots as celebratory shots. Your Worship, when we're dealing with sentence, we're not asking for condemnation. We're actually asking the court to lend the sentence or the punishment of this matter being brought to court and not being brought to court. Now, with respect, Your Worship, the accused was asked on this. He was asked, who do you think is behind this? And he gave the version. He said, I believe Forum is behind this. That was his version. This has caused a lot of consternation in this court. Even Your Worship yesterday said to my member of my team, Mr. Toby, why are we bringing Forum into it? And all he said was, it's in their heads, I've got to. And then Your Worship left it. Once it had been said, it was the state that had raised it. But it was unfair to attack Mr. Toby in that regard. Your Worship, also in regard to the financial aspect of this case on the taxpayers' pockets, with respect, Your Worship, that's a material misdirection. Could you imagine if we had to take everything into account in every maintenance can't get access to the court, the children that can't get their grants. Well, why don't we blame you for the potholes and for the weather as well, Your Worship, because they're unrelated. The NPA, if anybody, ought to have seen that the right was also bad. Here we sit with no aircon. Is that the accused's fault as well, Your Worship, because the funds that were used for this trial weren't used for that. With respect, Your Worship, it's an improper approach to take, and we misdirect in that regard. It would seem that you were appealing more to the public and justifying the decision that you're going to make rather than using a legal basis to do so with respect to Your Worship. They're not relevant factors in relation to sentence. We cannot, on the one hand, as Your Worship did, and I've got to say it's your right, your constitutional right to plead not guilty. You can have a trial. Oh, but by the way, you took up all these resources, therefore I'm holding you liable. That, with respect, is not a balanced approach, Your Worship. And Your Worship, this attitude is further borne out by Your Worship then carrying on through the time frame and saying, well, therefore the court is limited to what you're charged for and nothing more. Now, with respect to that implies that Your Worship wants to punish him for much more. We heard yesterday about all the different shots.
We heard yesterday about all the different shots. We know that there was only one shot in the charge sheet, one bullet in the charge sheet. There was only one ammunition. There was only one firearm. So it seems that Your Worship has misdirected Your Worship self in relation to the magnitude of what occurred that day. And it would be premised with respect then on the video that Your Worship allowed and then disallowed at the end. So we say that that's an incorrect approach to the entire trial, and more specifically the sentencing procedure, Your Worship. And then Your Worship dealt with the politics and that it's not a political party that has been convicted here. It's a particular accused. But there's no need, Your Worship. If you say I'm holding you liable as the leader of the EFF, there's no need to say I'm convicting or I'm not convicting our party. It's self-explanatory. Then Your Worship turned to what Your Worship referred to as an uncomfortable topic and said that Your Worship had heard all the witnesses and Your Worship said that politics and law don't mix. They must stay in their respective lanes. Now, Your Worship, while saying that with respect, Your Worship, and in your attempt to distance yourself from that's exactly what you, with respect, made yourself guilty of. Because your reference to the public out there, to all the people that have suffered on account of this, was more of a political speech than a judgment on sentence with respect, Your Worship. And this, Your Worship, was also what was displayed yesterday, as I explained, in the confrontation between Mr. Ngai and yourself relating to AfriForum, when it was the state who had said it referred to AfriForum. And Your Worship, another aspect that was highlighted and doesn't find any meaning is there was a debate yesterday, and even my learned friend wanted to continue further on the return of the firearm and what the correct procedure is. Your Worship, there can be no doubt, and Your Worship knows that Section 34, the court must make an order returning. The state can't decide halfway through a trial or at any juncture to return the firearm, and that ought also to have been part of Your Worship's judgment, that the rifle may be returned to its lawful owner. Your Worship identified the lawful owner in your sentence as Mr. Snowman, but Your Worship didn't go further and say, and he's now entitled to the return of his firearm because it wasn't handed by him, but it was given back to him after the event. But that wasn't taken into account. So a more benevolent approach would have taken those aspects into account. Now, the most distinguishing feature, Your Worship, between this Ngala Nzima case of Mdantsane, Your Worship, was there were victims. There was a dead child of 13 years old. There was an injured child of 13 years old. Here you have none with respect. There the judge in a higher court still found the compassion to deal with the bereavement and the loss of life and the injuries and still not impose a period of imprisonment on a person that had shot people, which is distinguishable on those facts, but it's far worse. And the simple fact remains, Your Worship, that to this day, the challenge was put out to my learned friend and to Your Worship to find any case dealing with what you call sugar-coated celebratory shots, we call celebratory shots, where anybody had been charged for it. And Your Worship says that's not a relevant factor. We say it is with respect. If one can have regard to how many soup kitchens are in the neighborhood, one can have regard to how many times this actually happens in real life.
And Your Worship, having berated the accused for taking so much of the court's facilities and time, then turned around at the end of it and said, each case is unique, everybody's equal before the law, and everybody has a right to a fair trial, so we're all equal. So, Your Worship, how do we find somebody more accountable on the basis that is the leader of a party, but yet we say we're all equal before the law? And Your Worship said this specifically, accountability of public officers weigh much more. It doesn't mean you are not treated equally, and I don't understand that concept. Specifically, Your Worship, when we have regard to the decision that we quoted in our heads of argument in the Constitutional Court, and ironically dealing with the EFF versus the Speaker of National Assembly, where they stated as follows, in reference to the case that did away with the death penalty, Your Worship, and they say, and I quote, at paragraph 235, it is after all the embodiment of the legendary Lady Justice, a dispenser of justice who's blind and deaf to images of any reports on the good reputation and entirety of personalities before her, but never misses any legitimate and relevant legal or factual points for or against any litigant. So what we're saying, Your Worship, is that justice must be dispensed without fear, favour or prejudice. It's known, it's accepted by Your Worship. That includes Lady Justice being blind and deaf, Your Worship, and not overemphasising the position that a person plays in society when it comes to sentencing them for conduct, which conduct, as we've stated, Your Worship, was over within minutes with respect. May I just have a look there? Your Worship also went further to say that the accused had been dishonest in his approach to the court. And with respect, Your Worship, there was no basis for that factual finding, particularly in relation to sentence. And this, Your Worship, then impacted on Your Worship's then finding that Your Worship could have regard to corruption cases and fraud cases dealing with dishonesty. And that goes back, Your Worship, to the issue that I raised earlier of being in a position of trust. It seems that reasoning permeated Your Worship's logic or reasoning throughout this matter, and we said that that is a major, irreversible misdirection on Your Worship's part. So in conclusion, Your Worship, what we say is that taking account of the crimes of which the accused was convicted, the interests of society and the personal circumstances of the accused, as well as the unique facts pertaining to this matter, a custodial sentence ought not to have been imposed. The imposition of a custodial sentence is startlingly inappropriate to the extent, Your Worship, that it induces a sense of shock. May I just listen to my colleague?
The police. Please, sorry, can you just a minute? We are returning. I couldn't hear what that last sentence
I'm instructed by Lottie to point out, and it's a valid point. If one has regard to the fact that there's never been a case of this nature, then we're all in agreement on that. So this is a novel situation that we seem to be dealing with judicially. So there's no sentence, there's no precedent that one can say, oh, well, the other case is exactly the same, and this is what they did for celebratory shots. If you look at Oscar Pistorius, if you look at all the other cases, there were people in a built-up room. He was given a non-custodial sentence for discharging. He wasn't charged with the possession, but it's very similar facts. This could even be regarded as a duplication. Possession, and there are cases that say possession of the firearm, possession of the ammunition is impossible without, I beg your pardon, discharge of a firearm with ammunition is impossible absent the firearm and the ammunition. Why should they be treated separately? And that's the case where we have different sanctions, different punishments on each and every one of those three charges, one being a 5-year sentence, Your Worship, with respect. So if we have regard to those and we do a comparative, it cannot with respect be said that this appeal is doomed.
Lisa, I'm not sure if you ready based on what you've heard. I no, there's not. I was yes. I realized that's why.
My working notes.
Yes, no, you can't. No, I fully agree. I understand. I was thinking, that's why I'm saying, has he listened, and then does he need a few minutes to prepare a reply? Because I've memorized. I don't require. I've listened. I don't need your working document. You need a few minutes, Advocate Caesar? Okay, thank you.
My understanding is correct. Justification should be with Section 309 of the Criminal Procedure where leave to appeal is applied from the government institution or to a high court. Insofar as the leave to appeal application is in respect of conviction and in respect of sentence. One of the factors that has been mentioned, if my memory serves me correct, and counsel can point out to me whether it is inaccurate, that Your Worship failed to take into consideration that the principles in Rex versus Blom relating to the only inferences relating to the incident in question, that the accused did in fact possess the firearm and that he did in fact fire those shots. This was our submission. In that regard, the court took into consideration all the evidence, including the video evidence, which the court deemed to be admissible. And like I've already said previously, that was enough evidence for the court to come to that particular finding that the accused did indeed fire that particular shot, and that there are no prospects of success relating to the conviction and sentence in this regard. If we deal with applications for leave to appeal, I've heard counsel say there are good prospects, but that's not the only requirement. The mere possibility that another court might come to a different conclusion is not enough to convince the trial court to grant leave to appeal. The reason for that, why the courts have taken such a view, if Your Worship is of the view that the conviction was correct, allowing an application for leave to appeal will absolutely amount to a waste of judicial resources when there's no prospects of success. I submit that counsel might have an arguable case, but if there's no realistic chance, insofar as the conviction is concerned, that he will succeed. It has been pointed out in so many cases, the Supreme Court of Appeal has stated what is the test of reasonable prospects of success, postulates it's a dispassionate decision based on the facts and the law, that the Court of Appeal could reasonably arrive at a conclusion different to that of the trial court. In order to succeed, therefore, the appellant must convince the court on proper grounds that he has prospects of success on appeal, and that those prospects are not remote but have a realistic chance of succeeding, most required to establish than that of a mere possibility of success. A mere possibility of success, an arguable case, like I said, or one that is not hopeless is not enough. This is basically what I said counsel have argued before, Your Worship. There must be a sound, rational basis to conclude that there is a reasonable prospects of success. Insofar as the sentence is concerned, that before I go there, I just want to say the court has thoroughly considered all the evidence. Like the court pointed out earlier, the court had a long judgment dealing exactly with every issue that has now been raised by counsel, whereas the court has made those findings in respect of each of the points raised. It's it's my submission insofar as the conviction is concerned, there is no reasonable prospect of success and no realistic chance that it will be overturned on appeal. And so far as the sentence is concerned, Your Worship is of the view that I did request that the 15-year sentence must be imposed. I also provided alternative sentences which might be imposed to the accused. I'm satisfied with the sentence that was imposed by this court. As a matter of fact, I find it to be fair, and regarding to the facts of this case, there's also no prospects of success relating to this particular sentence, that the different court will come to a different conclusion, and that the court should dismiss this application. The issue with bail, I will deal with Your Worship as we go along, depending on the court's finding whether there are indeed prospects of success or not. Thank you.
Start out with the arguments made about the correct test. It seems that my learned friend wishes us to argue that your worship is wrong, but we don't have to argue that you are wrong. It is on appeal that we will argue that you are wrong. What we are dealing with today is merely a question of whether there is a realistic probability that another court might come to a different conclusion. In other words, is there a realistic prospect that that will be the case, both on the questions of fact and on the questions of law. So it's crucial to underscore that test. And the exercise is also not a repetition of the case that your ladyship has had. Your ladyship is now functus officio in relation to your judgment. So we don't have to persuade your ladyship that you were wrong. We simply have to show that someone else looking at the same facts might come realistically to a different conclusion. The only argument made by the state, and it's important to examine their case, what they have said now, is around R versus Blow. That's the only thing they have said. Now, your ladyship, if you contrast that with the case that has been made on behalf of the accused, R versus Blom is one aspect, but there are so many other grounds for leave to appeal that have been advanced. The reality, your worship, is that none of those have been responded to. What you have is just a generic submission that there is no reasonable prospect of success, and there is no reasonable likelihood that a different court looking at the different facts might arrive at a different conclusion. So in effect, you are then not dealing with an application on conviction that has been seriously contested by